Good afternoon. Good afternoon and welcome to the Herbert W. Vaughan Lecture. Mr. Vaughan was a 1948 graduate of the Harvard Law School who practiced law with distinction for 47 years at the Boston law firm of Hale & Dorr, now Wilmer Hale. Mr. Vaughan endowed the program to, in his words, promote and advance understanding of the founding principles and core doctrines of American constitutionalism. He asked that this statement be read at the beginning of each of these events. In my judgment, the Constitution of the United States is the greatest practical achievement of political science. It is a testament to the extraordinary gifts of creativity, prudence, and high-mindedness possessed by the founders of our nation. May you be guided and inspired by their genius as you meet the challenges of the present day. Today's Vaughan lecturer is Richard Ekins. Professor Ekins is Professor of Law and Constitutional Government at the University of Oxford and Distinguished Global Professor of Law at Notre Dame Law School. His scholarship focuses on questions in constitutional law and practice and in legal and political philosophy with a particular focus on lawmaking, interpretation, and self-government. He has been a fellow at St. John's College, Oxford since 2012. Professor Ekins is the co-author of the book Legislative Rights, Securing Human Rights Through Legislation, and the author of The Nature of Legislative Intent. He will speak for about 40 minutes and then we'll take questions. Professor Ekins.
Thank you very much. Well, thank you, Professor Goldsmith, for that kind introduction. I'm honoured to be here to give the Vaughan Lecture this year and to be asked to give it. My first time here in Harvard, I have to say, but I was pleased to watch with appreciation my friend Joel Alicia give the Vaughan Lecture last year, and it's a privilege to follow in his wake. My topic, of course, is textualism, the leading approach to statutory interpretation here in the United States. And you'll be familiar, I'm sure, with Justice Kagan's remark here at Harvard Law School 10 years ago that we are all textualists now, as well as with her partial repudiation of that claim 3 years ago in West Virginia versus EPA, in the course of challenging the majority of the court for its illegitimate departure, in her view, from the text of the Clean Air Act. Well, as Justice Kagan's remarks suggest, the ascendancy of textualism in the United States may be an unstable development, and the apparent consensus may conceal more than it reveals. What exactly textualism is, what it requires of judges, may be hard to pin down. There are many textualists on the bench and in the academy, and quite properly they do not all think alike. And perhaps different theories, notably textualism and purposivism, have converged over time, such that there is no sharp line distinguishing textualism from anything else. Still, there do seem to me to be some shared textualist commitments that warrant investigation. So I'm going to put before you a series of claims that seem to me to be characteristic of textualist thought and practice, and then question their merits. I intend to be critical of textualism so understood, but I should say now, and will explain further later, that there is a truth in textualism that needs to be recognised and affirmed. If textualism can be crudely summarised as a theory that focuses on the plain or ordinary meaning of the statutory text, my own view is that the object of statutory interpretation is to infer the intention, principally the intended meaning, of the legislature that enacted the statute. The text is indispensable to that process of inference, but it's legislative intent that controls. And I think that places me firmly in the centre of the common law tradition and in good company with Aquinas, Blackstone, and Hobbes, amongst many others. Now that said, my position may prove similar in practice to that taken by some leading textualists. When I published my book on legislative intent some years ago, which Professor Goldsmith mentioned, one of my favourite reviews of the book was entitled Intentionalism Justice Scalia Could Love. Now, whether Justice Scalia would have agreed, I'm not so sure, but the review had a point, as I shall try to make clear later on. Well, let me proceed then to set out 10 dogmas of textualism. The first dogma, the text is the law. It's a familiar claim, and it may seem straightforwardly true. As Justice Scalia put it, the text is the law, and it's the text that must be observed. But the text of the statute is not itself the law. Indeed, it's a mistake to think that a statute is primarily a text. The enactment of a statute changes the law, and the law that we have is the way it is because Congress enacted the statute, taken together with other relevant statutes and propositions of law. The law is a set of propositions, a set that's changed somehow by the enactment of a statute. Well, usually changed. It's possible for Congress to enact legislation that changes the text of the statute book, but does not change the law itself. Codification and consolidation may have this effect. In simplifying or restating the text of the statute, Congress does not intend to change the law. There's a difference between statutory formulation and legal proposition. One can achieve the same change in the law by way of different formulations. Now, consider also when Congress makes a drafting error, or scrivener's error, as you term it. Here, the words on the page do not constitute the law. It would be a mistake to say, as judges sometimes do, that the courts rectify the error. The point instead is that they recognize the error. What Congress has done, the change in the law that it has made, and I would add, which it intended to make, is not stated in the text. The enactment of the statutory text makes a contribution to the law. Now, my point is emphatically not that Dawkins was right and that legislation is simply raw material from which Justice Hercules conjures up the law he thinks that we should have. In enacting a statute, Congress makes a targeted change to the law that existed before the statute came into force. The text of the statute does not necessarily state the legal propositions to which it gives rise, that is, which it makes legally correct. We can and we do reason individually and with each other about what precisely is the change to the law that the enactment of the statute and its coming into force makes. The statute is not a text that states the law. The statute's an act, hence the term Act of Congress. But it's not just an act of language use, uttering the text of the statute to convey some meaning to the subjects of the law, although it is this in part. First and foremost, it is an act of legislating, an exercise of legislative authority. The mischief in the claim that the text is the law is thus that it obscures the nature of the statute. Now, textualists do have something to say about what Congress does when it enacts a statute, but my concern is that the conflation of text with law overlooks the importance of action. That is, the statute is approached as if it floated free, rather than being an exercise of authority. Now, one can see why the claim that the text is the law has such a hold on the legal imagination. And I think Justice Gorsuch spelled out part of the rationale when he said in Bostock versus Clayton County that, quote, only the written word is the law and all persons are entitled to its benefit. In other words, judges uphold the rule of law when they adhere strictly to enacted text. It would certainly be wrong for judges to downplay the significance of the enacted text and to take it only to have a distant connection to the law that the enactment of the statute makes. But with respect, Justice Gorsuch and others beg the question. All persons are entitled to the benefit of the law, which the judge should strictly uphold. The question that needs to be answered is how the enactment of the statute makes law. I say that Congress enacts legislation in order to change the law, with the text of the statute serving as the canonical formulation of its lawmaking act, the promulgation of its lawmaking choice. What all persons are entitled to is strict adherence to the law that Congress chose to make. The second dogma, the plain or ordinary meaning of the statutory text is its legal meaning. Now, this claim is more specific than the claim I've just considered. It's more plausible insofar as it looks for the legal meaning of the text, as if searching for a way to connect the law that a statute makes to the detail of the text itself. But the question that the judge should ask is not, what did the words mean, but what have the words been used to convey? The legal meaning of the statute is not its plain or ordinary meaning, but the meaning that one can readily infer was intended by the Congress that enacted the statute. Textualism misunderstands language use. Any sentence will have a semantic content, which can be isolated and considered. But the semantic content of a sentence is not what a person means in uttering the sentence, or at least is not necessarily what the person means. Language users routinely mean more or less, or something quite different to the semantic content of the sentences they utter, relying on their audience to infer the meaning they intended to convey. Now, we sometimes mean exactly what we say, but what we say in terms of semantic content is much more limited than what textualists have in mind when they invoke plain or ordinary meaning. Now, I think most textualists would readily agree and would say that plain or ordinary meaning is not literal meaning, but rather is the meaning of the text in its context, which is to say what a reasonable reader would understand the text to mean. Now, I'll have more to say about context in a moment. For now, my point is that a reasonable reader is one who aims to infer what the author intended. Why? Because the reader will know that language use is an action, somebody's intentional action. Sentences do not float free in the world. They're used by an agent to convey some meaning. That is, an agent makes use of the semantic content of the sentences, the acting person or body a body of persons utters, in order to make clear to the audience his, her, their, or its intended meaning, intending the audience to recognize this intention. The reasonable reader that textualism imagines is one who knows little about the sentence's author. The risk in isolating the so-called reasonable reader from the author is that one simply stipulates the author and imagines or freely postulates, in the name of reasonableness, the author's meaning, which risks remaking the statute in one's own image. Now that, of course, is the vice that textualists abhor. And my point is not that the textualist judge will simply read his or her politics into the statute. What I mean is that the reasonable reader the judge imagines does not exist. The reader will only be reasonable to the extent that he or she makes reasonable inferences about intended meaning. While I think the textualist judges will often interpret legislation correctly, there must be a standing risk that textualism will slide into literalism or into inattention or even willful blindness to the way in which Congress made use of language. The nominal priority of plain or ordinary meaning encourages the textualist judge to think that the legal meaning of the statute is available without inference about what Congress did. Thus, the textualist judge may lean too heavily on the semantic content of the statutory text, underplaying the extent to which it's always open to Congress to convey something different to this semantic content, which the judge should recognize and uphold. One can see the confusion at work in the famous case of Smith versus United States, where a sentencing enhancement attached to any person who used a firearm in relation to a drug offence. The question, as many of you will know, was whether the defendant had used a firearm when he offered it in disassembled form as collateral in a drug trade. The court divided over the question of the ordinary meaning of the word use, with the majority saying the defendant had obviously used the firearm, and Justice Scalia forcefully maintaining in dissent that the ordinary meaning of use in this context meant use as a firearm. Now, I think Justice Scalia was right about what should be done here, but wrong about why. The meaning of use is just use. It's not used for any purpose whatever, as the majority asserted, nor is it used as a firearm, that is, as a weapon, as Justice Scalia claimed. The semantic content of the statutory text was incomplete and required pragmatic enrichment. The question should instead have been about how Congress used the term use in this context. Here, Justice Scalia had good reason to think Congress used the term to convey use as a firearm. But this was not a conclusion about plain or ordinary meaning, but about intended meaning. That is, Justice Scalia should have recognized that he was honoring Congress's use of language. The third dogma: context makes sense without intention. Now, textualist judges and scholars take pains to note that meaning is contextual. However, I don't think their appeal to context makes sense apart from intention. The context of language use is the set of considerations that are common to author and contemporaneous, or at least expected, reader, which the author is able to exploit to convey his, her, their, or its intended meaning to the reader. Or if you like, context is a shared predicament, the situation in which we find ourselves. The point is that the significance of context is what it reveals about the author, which helps frame the inferences we make about what meaning was intended. That is, context does not generate meaning, but helps us to discern it. What we, the readers, must do is to reason about what meaning the author intended to convey. The other sentences that make up the statute form part of its context, its internal context, if you like. The law as it stood before the enactment forms a major part of the context, as does the history of legal change in this domain up until this point. Why? Because this is all highly relevant to how Congress is likely to have reasoned, how it's likely to have reasoned and acted, and Congress knows that we know. The context of enactment also includes, obviously enough, many considerations that are relevant to the policy domain in which Congress is acting, which will help inform the judge's inference about Congress's intentions in legislating, about the targeted changes that it aimed to make to existing law. When textualists appeal to context, they routinely reason about apparent legislative purposes and about the significance of the existing legal background against which Congress acted. Judge Kovner, in her excellent Scalia lecture in March this year, noted that arguments from purpose seem to arise in various recent Supreme Court judgments, arguments that are not closely grounded on textual analysis in the way that Justice Scalia had otherwise commended. And John Manning argues that textualism and purposivism remain distinct insofar as, while the textualist jurist will consider semantic context and policy context, when semantic context supports a plain or ordinary meaning, this cannot be displaced by policy context. The problem, it seems to me, is that textualism thus ends up tolerating with equanimity the prospect that the legislature acted for any reason or no reason at all. The better course of action is to aim to infer what the legislature has done in a way that makes sense of its presumptively rational act of language use and legislating. The fourth dogma, the Constitution requires textualism. Justice Gorsuch has said that textualism honours only what survived bicameralism and presentment and not what hasn't. And he made the same point in Bostock, saying, quote, "Only the words on the page constitute the law adopted by Congress and approved by the President," end quote. Bicameralism and presentment are not unique to the United States. In Britain, an Act of Parliament requires the assent of the House of Commons, the House of Lords, and the King. True and important that royal assent is now routinely given, although that's just as if the President seldom or never vetoed legislation. Now, notwithstanding this similarity in legislative process, the common law tradition has long maintained that the legal meaning of the statute turns on inference about what Parliament intended. One needs more than a bicameral structure or the possibility of royal or presidential veto to reach the conclusion that the plain meaning of the text is the law. The Constitution vests legislative power in Congress, which thus has authority to legislate. The subjects of the law have a duty to accept and uphold Congress's exercise of that authority. And the question should always be whether some method of interpretation is consistent with this duty, whether the judge or other interpreter is honouring or defying legislative power. In enacting a statute, Congress is not introducing abstract purposes into the law, which the judge then has authority to pursue as he or she sees fit. Neither is Congress just introducing a statutory text into the mix, which judges should read as a series of sentences that result in various changes to legal rights and duties. What Congress is doing is making targeted changes to the law, changes that it aims to bring about by uttering the statutory text in context, where its intended meaning will be recognised. The main point of the textualist appeal to constitutional structure may be to reject the use of legislative history. And I've got a lot of sympathy for that argument. Legislative history does seem to me ripe for mischief, and there was good sense in the traditional common law exclusion of this material, which went hand in hand with a focus on the intention of the legislature. Now, Judge Easterbrook contrasts the text, which he says is the law, with the private intent of the legislators. Now, what that contrast may obscure is the public or manifest intention of the legislature. That is the intention of Congress that it makes clear by uttering the statutory text. Nothing in the Constitution's provision for the legislative process requires or permits the judge to close his or her eyes to that intention and instead to focus on the text alone. The fifth dogma. The relationship between Congress and the people makes plain meaning authoritative. Now, the claim, as I understand it, is that the law that Congress makes in enacting a statute turns on how the American people can or do understand its enactments, which makes plain meaning decisive. Textualism on this view is a theory of statutory interpretation that gives effect to and is grounded on the constitutional relationship between Congress and the people. Now, in Britain, the King and Parliament is sovereign. In the United States, maybe the people are sovereign and Congress is an agent of the people. Certainly, Congress has a more limited lawmaking competence than the British Parliament. But within its limited competence, it has authority to make such law as it sees fit. The textualist judge or scholar who makes this argument aims to prioritize the way in which the people understand legislation, which makes Congress's intentions beside the point. Now, I think this argument attempts to pull itself up by its own bootstraps. The way in which the people should understand legislation turns on how Congress legislates. Now, distinguish the people plural, as in the ordinary people, from the people singular, the body politic. The ordinary people should understand legislation by seeking legal advice. They should know that Congress has authority to legislate and that members of Congress can fairly be held to account for the changes to the law they make, for which they are responsible. But it does not follow that the meaning of acts of Congress is their plain or ordinary meaning, as opposed to the meaning that a competent lawyer would think that Congress intended to convey. As for the people singular, it vested legislative power in Congress, and it's entitled to expect Congress to legislate, not simply by producing texts, but by making targeted changes to the law. The exercise of legislative power requires promulgation of lawmaking intention, but this is quite different from providing that the law that Congress made or makes turns on how the people understand the text of the statute, read in isolation from the intention of Congress. Well, this argument from the people, from how the people understand legislation, it risks leading the judge away from the moment of enactment, at which Congress acts to change the law. The law that a statute makes is not determined by the way in which ordinary people read it now. Now, textualists are, rightly, to my mind, attentive to the importance of the moment of enactment, but the form of this argument from the people's understanding is in some tension with that focus. The sixth dogma, realism about the legislative process, establishes the priority of plain meaning. Now, I have no quarrel with attending closely to the nature of the legislative process, but what is it that textualist judges and scholars see when they look at legislating? Well, they stress the importance of disagreement amongst the legislators, the power of minorities to block the passage of legislation unless and until their concerns are accommodated, the resulting importance of the legislative bargain and of compromise, as well as the prospect that legislators will not agree on what legislation means or is intended to do, but will instead simply agree on a text, taking their chances with how it will subsequently be interpreted. There may be a tension between legislative bargaining, in which the currency is plain meaning, and what one might term a semantic lottery, where there is no meaning until adjudication. But perhaps one form the legislative bargain takes is agreement on a text, the meaning of which is yet to be determined, where each side is content to fight its corner in court in due course. And that seems to me a very unattractive account of legislating. It doesn't, of course, make it false. Still, I think one should be concerned that what is called realism here is really just cynicism. Public choice theory may have some explanatory power in American political life, but it risks systematically misunderstanding the reasons for which legislators act in adopting the text they do. And what we expect to find will certainly bear on what we are likely to find. The importance of legislative compromise does not establish the priority of plain meaning. One should certainly be attentive to the plan on which the legislature seems to be acting, which may well include compromises that limit its pursuit of the ends for which the legislation otherwise seems to be enacted, or that bears on the means chosen to those ends. No legislature pursues an abstract purpose, come what may. The question is always what means it chose to certain ends, which are in turn means to further ends. What's missing from the textualist analysis of the legislative process is recognition of the importance of Congress itself forming the institution that exercises legislative power. The disparate priorities and intentions of the legislators, plural, are taken to undercut the coherence of the legislative act, such that we should expect legislation to be a hodgepodge, a mess. This analysis underplays the moral importance of Congress acting like a rational agent, making targeted changes to the law that are non-contradictory and presumptively coherent. What the people of the United States are entitled to expect from their legislature is not that its enactments will mean whatever they appear to mean when one reads them in relative isolation and without attending to the plan of action they may disclose, but rather that their legislature will be taking its responsibility seriously and making reasoned changes to the existing law. So textualism risks building up a misleading picture of the legislature. It's wrong to assume that the legislature is inscrutable, that one can never know why it acts as it does, because the nature of congressional politics renders it incapable of acting coherently. Now, this textualist analysis of the legislative process is closely related to the seventh dogma, which is that there is no legislative intent, or if there is, it's undiscoverable or redundant. Now, for many textualists, this is a fundamental claim. Judge Easterbrook and Justice Scalia were both forthright in rejecting legislative intent, although Justice Scalia's criticism of it at times seemed limited to so-called subjective intention, and especially to recourse to legislative history. John Manning, by contrast, seems to accept that there is legislative intent in the minimal sense envisaged by the legal philosopher Joseph Raz, which is to say that the legislature intends to enact this text, which then has whatever meaning the conventions of interpretation dictate. For Manning, this minimal intention thesis is a way to acknowledge that legislation is deliberate, without conceding that the object of interpretation, the object of statutory interpretation, is legislative intent. On the contrary, textualism would seem to follow from minimal legislative intent. In the alternative, perhaps there's no realistic prospect of discerning what Congress truly intended, such that the only safe course of action is to take the plain meaning to be the intended meaning of Congress. Now, this argument understates the capacity of an institution like Congress to form and act on intentions. The minimal intention thesis is not a persuasive account of how legislators jointly understand their interaction as members of Congress, with reasonable legislators constantly considering what it is that they will be doing jointly if they enact this statute, and what intention Congress will be manifesting. Legislation is designed, as I've been saying, to make targeted changes to the law. In making inferences about why the statutory text was framed the way it was, we are attempting to recover the plan of action on which the legislators jointly acted as one single agent. The alternative, which some, but I think only some, textualist jurists embrace, is to conceive of legislation as mindless, to hew ever more closely to statutory text in isolation. Now, for good reason, judges are quite reluctant to assume that legislation is mindless. Still, the textualist skepticism about legislative intent is significant. Let me consider King versus Burwell, one of the Supreme Court's two Obamacare judgments. The question, as you probably all know, was whether tax credits were available to persons who were enrolled in a health insurance plan through an exchange established by the federal government. Section 1311 of the Affordable Care Act provided that each state shall, not later than January 1, 2014, establish an American Health Benefit Exchange, referred to in this title as an exchange, for the state. Then in Section 1321, Congress made provision for the failure of the state to establish an exchange by the required date, stating that, quote, the Secretary shall establish and operate such exchange within the state, end quote. Section 36B of the Internal Revenue Code, introduced by the Affordable Care Act, provided that an individual would be entitled to tax credits in relation to the premiums for a health plan, quote, enrolled in through an exchange established by the state under Section 1311 of the Patient Protection and Affordable Care Act, end quote. And the majority of the Supreme Court said Section 36B was ambiguous, should be understood to include an exchange established by the federal government, reasoning that a fair reading of legislation demands a fair understanding of the legislative plan. Justice Scalia in dissent was withering, and this is what he said. Words no longer have meaning if an exchange that is not established by a state is established by the state. It is hard to come up with a clearer way to limit tax credits to state exchanges than to use the words established by the state. And it is hard to come up with a reason to include the words by the state other than the purpose of limiting credits to state exchanges. Now that may seem unanswerable, but in fact I think the majority was right here. Congress's plan of action, its manifest legislative intention, was for any person enrolled in an exchange established under the Affordable Care Act to be entitled to tax credits. Justice Scalia read Section 36B as if it had said that tax credits would not be available in relation to an exchange established by the federal government. But it did not say that, and had it had any intention of limiting the availability of tax credits, saying this would certainly have been a clearer way of doing so. Justice Scalia took Section 36B to be crystal clear, and he reinforced that argument by appealing to the variety of language used elsewhere in the Affordable Care Act. What he failed to do with respect was to explain the relationship between sections 1311 and 1321, or failed to explain adequately. That is, the relationship between exchanges established by the state and by the federal government. Now, the majority, I think, overcomplicated matters by trying to say that section 1321 somehow empowered the Secretary to establish an exchange under section 1311, which meant they said that established by the state in section 36B meant established by the state or by the federal government. The better view, I suggest, is that section 1321 empowered the Secretary to establish an exchange which counts as an exchange established under section 1311. As the majority pointed out, unless such a relationship holds, then virtually none of the Act's requirements apply to an exchange established by the federal government under section 1321. The dissent's reading of the Act is not a plausible understanding of what Congress did. Denying legislative intent heightens the risk of misreading the statute. Now, I rather fear that at times textualist judges and scholars make a virtue of this vice, embracing what are in effect acontextual, unintended readings of legislation. And my next two dogmas concern this point. The eighth dogma: the interpreter should be hard-headed or even hard-hearted. Textualist judges are likely to attempt to isolate the statutory text from evaluative questions about the reasons why the legislature might have acted as it did. And they'll remain open to the conclusion that the legislature acted for any reason or no reason that we can discern. It's a mistake to try to banish evaluative reasoning from statutory interpretation. And I say that, I think, as someone with a very firm commitment to legislative authority. The point of reasoning about the legislature's reasoning is not to remake the statute in one's own image, but to infer what was decided by Congress and to avoid misreading the statute. And one can misread a statute by shutting one's eyes to Congress's intended meaning, just as much as by attributing to Congress abstract purposes that one wishes it had pursued. If I'm right, textualist judges might be disposed not to hesitate in face of hard conclusions. That is, the textualist judge is likely to refuse to strive to avoid absurd outcomes, or relatedly, to recognize drafting errors. And the textualist judge will reject equitable interpretation out of hand. Now, I say that the foreseeable consequences of an enactment are relevant to what Congress was likely to have intended and chosen. So a reading of a statute that culminates in absurdity, in self-refutation or nonsense or harsh treatment is unlikely to have been intended. Now, it's true, Congress may adopt a policy that's mistaken or unwise, which judges cannot revise, but it doesn't follow that judges should be quick to conclude that Congress has acted in this way. Now, as for equity, I can understand the textualist concerns, and a good legal system will certainly minimize the occasions on which equitable interpretation arises. But I think one has to wrestle with the limits of legislative foresight, the risk of exceptional cases arising. We should hope that cases like Riggs versus Palmer do not come along often, but it would be a mistake to reject out of hand the prospect of their lawyerly and law-governed resolution, not least since so doing would leave open the door to a Dworkinian approach. Consider Yates versus United States, where the question was whether an undersized fish thrown back into the ocean after the Coast Guard had left the scene constituted a tangible object, and a statute that made it an offence knowingly to alter, destroy, mutilate, conceal, cover up, falsify, or make a false entry in any record, document, or tangible object. Now, for the dissenting judges, led by Justice Kagan, the point was an obvious one, and the majority's concern not to overread the breadth of the statute was derided as betraying a legislative disposition. But the majority's caution was well taken, with the history of the enactment and the terms in which it was framed militating against the conclusion that it in effect proscribed any evidence tampering. Now, the dissent made a virtue of its refusal to resist Congress's objectionable overcriminalisation, but that may have led the dissent too quickly to conclude that the statute did have this broad reach. That leads me to my ninth dogma. The point of an interpretive method is to restrain judges, or perhaps to be seen to restrain judges. Many defences of textualism stress the overwhelming priority of restraining judges, such that the law that they apply in disputes is not made by judicial fiat. The concern seems to be more that the law is not made by the judge, rather than that it is the law that was made by Congress, which had authority to make it. Now, why this concern? And why the related pride, if I may call it that, in biting the bullet? Well, the reason may be that strict adherence to the method proclaims the judge's political neutrality. By failing to reason about legislative reasons, or at least by failing openly to do so, the judge disavows any ambition to gloss the statute with his or her own preferences. Reflecting on Bostock, Tara Grove contrasts flexible textualism with formalistic textualism, where the latter identifies the plain or ordinary meaning of the text in light of a more narrowly drawn context. And the advantage of this approach, Professor Grove reasons, is that it more clearly signals that the law is determined by something other than the judge's own political preferences. The relative unpredictability of statutory interpretation disputes, in which conservative and liberal textualist judges alike do not vote their politics, is thus a feature rather than a bug. Now, that distinction is similar but not quite the same as that drawn by my friend Jeff Pałżynowski between a formalism of authority and a formalism of method. The former focuses on congruence with authoritative lawmaking acts, while the latter is concerned with a method that restrains the judge, and I would add that is seen to restrain the judge. Now, I support the formalism of authority, and I take flexible textualism to be well on the road back to recognition of the constitutional priority of legislative intent. The formalism of method and formalistic textualism seem to me to let slip what should be a focus on Congress's exercise of legislative authority, and to be liable to result in selective literalism. Now, in West Virginia versus EPA, as I mentioned at the start of this lecture, Justice Kagan accused the majority of abandoning their textualist convictions, saying, "The current court is textualist only when being so suits it. When that method would frustrate broader goals, special canons like the major questions doctrine magically appear as get-out-of-text free cards." Now, if that were true, it would certainly suggest textualism is failing to restrain judges, although the fault may lie more in judicial hypocrisy than in a bad theory. But Justice Kagan's sceptical reference to special canons leads me to my 10th and final dogma, which is that the text alone suffices. And this is a major topic, and I'm going to handle it extremely briefly. I think it brings us full circle. The text of the statute is not the law, in part because the legal meaning and effect of the text turns on the intersection between this text, or rather this legislative act, and other legal rules and aspects of our interpretive regime. Now, Professors Bode and Sachs term this the law of interpretation. I have my disagreements with how they frame the practice of interpretation, but it's true and important that one cannot understand the legal meaning and effect of an enactment without reasoning about a host of other rules and presumptions. The text alone is not enough. Now, textualist judges have no difficulty in affirming linguistic canons of interpretation, even though it's questionable whether they can explain those canons without reference to legislative intent. But substantive canons, such as the charming Betsy canon, constitutional avoidance, presumption against retrospectivity, these are more of a challenge for textualists, as Professor Amy Coney Barrett, as she then was, recognised in a major article 15 years ago. They're a challenge because they temper the application of what the judge otherwise takes to be textual meaning, and yet they're supposed to be beaten back when the text is clear. Substantive canons stabilise some expectations about good legislative practice, and rightly so. In making sense of the way in which Congress exercises its legislative authority, one should not conceive of it as a language user whose reasoning cannot be understood. An act of Congress cannot be understood without reasoning about the application of default rules, which Congress may have intended not to displace or may have qualified in part, or about presumptions about legislative intent, which frame how we understand Congress's reasoning and choice unless and until they are beaten back by evidence of contrary intent. In this process of inference, the statutory text is utterly vital because it provides the most obvious and important evidence about Congress's intentions. But it is just not the case that the statutory text is or could responsibly be considered in isolation, without some awareness of a complex and partly contingent interpretive regime, which Congress exploits in order to make clear its intentions of how the law is to change. I've argued in effect that textualism develops or presupposes a bad theory of language, of legislative action, of legislative power, and of judicial power. But I think textualist judges will often be better in practice than their theory itself would allow us to predict. And textualism might still be a better approach than many of its rivals. There is a truth in textualism, which is that the text of the statute is extremely important, and the responsibility of the interpreter is to make sense of the rational act of language use, that is the enactment of a statute, the meaning of which is established at the time of enactment. Every judge should be alert to the risks of downplaying the detail of the text, glossing the act of Congress with abstract purposes that overlook the legislature's more specific means-end reasoning. So we should recognize the truth in textualism, be cautious about arguments from purpose, and skeptical about appeals to legislative history. While the object of statutory interpretation is legislative intent, we should aim to develop inferences about intention that are grounded in text and context. Acting otherwise would risk failing to honour the exercise of the legislative power. Thank you very much. Please. Yeah. Oh, there's a microphone coming.
Thank you for the talk. One question I have is, what should we do with enactments from Congress where members of Congress are open that they have not read the bill that they are voting on? In what sense can there be intention behind an enactment where people are self-consciously not paying attention to the text?
So it's a good question. I think it's, although in one sense that admission is slightly shameful, it's another way of recognizing the reality of the length of bills and the scale of the legislative enterprise. And there would be nothing wrong with the division of legislative labour, whereby legislators and parties don't undertake to read every bill themselves. They rely on their colleagues to some extent. I think the answer to that is partly that legislative intent doesn't consist in a kind of aggregation of the intention of each individual legislator. It turns on what the legislators are doing together. And that means, well, what is open to them to think they're acting on jointly? Now, if no legislator ever read a statute or a bill, I think there would be a serious problem and clearly be grossly irresponsible in the mode of legislating. But the fact that individual legislators don't understand the act in which they are participating doesn't make it the case the legislature itself does not have an intention. I think that distinction is an important one, and it's, I think, a distinction recognised by thoughtful legislators themselves, who wouldn't think, well, we're not doing anything because I haven't read the thing, and we're not doing anything meaningful or intentional or thoughtful. There's a question at the front here, I think, but unless it's gone. So.
Richard, I think you make a really good point that if we're asking what would the reasonable reader think, and we're sort of using that fiction, the truth is often the reasonable reader is trying to figure out what the legislator intended. But a textualist might argue that a standing intent of maybe every modern legislature is that they want their language to convey what they anticipate the reasonable reader would pick up. So is there sort of like a circularity there in terms of maybe the legislature does intend for us to interpret their language the way that sort of something like a reasonable reader fiction would pick up?
Well, they definitely want their intention to be understood. But I think this is not unique to legislating. It's a feature of communication, full stop. There's reciprocity between the expectation of the speaker about how they will be understood and the way in which the reader then proceeds. And there's a to and fro there, I think, that you will work out, well, how could they have understood themselves to be conveying something? Is it conceivable they could have thought this would be inferred? They want uptake. I mean, this is a general feature, I think, of language use, of which legislating, in this regard at least, is not exceptional.
So Richard, thank you so much, Richard. Extremely illuminating. I have a suggestion, I think, relevant to your first point and your last point.
Thank you.
And a lot in between. I think law is being used in two different ways in some of these debates and in your disagreement with Justice Gorsuch. So when he says only the written word is the law, and you say, no, a statute isn't the law is a larger network of propositions and rules of interpretation and background, substantive canons, and so on. I think you're just using the word in different ways that is unfortunately concealed in English, because English fails to draw a distinction that's drawn in many other languages between in Latin, lex and use, in Spanish, ley and derecho, in French, loi and droit. So Gorsuch is saying that the statute is lex, it's the enacted text. You're saying that law includes more than lex, it includes use or droit or derecho, which is this larger network of propositions. And so the debate between you and Gorsuch, I think, really is there this larger category? And on that, I think there clearly is. And I think Justice Gorsuch thinks there is when he's not self-consciously advancing theoretical propositions. That is, he constantly draws on rather ambitious background principles of what he calls democracy and liberty and so on, that he takes to be part of the law. He draws on substantive canons. He draws on all sorts of things that are not just lex. So I think just drawing that distinction might clarify the disagreement you're having with him, maybe? Just a thought? Yeah.
Well, thank you for the thought, Adrian. I find the distinction between lex and use sometimes a bit befuddling, which is why I don't make use of it, although I continue to think about it. And so I think Justice Gorsuch and others, I mean, as I say, I think people are often better than their stated principles, which is good. It's the right way around. And so as I say, I think textualist judges will often be successfully inferring the change in law that's been made by the legislative act, even if their theory would not naturally lead to that conclusion. I think, though, that even using the distinction between lex and use, there's a mistake going on, a further mistake going on, which is to conceive of the authoritative act, which I think would be the lex on your account, as something that is too spare and empty, namely just words on a page. Now, then context gets fit in, but it's not. We can put off for a fair bit of this discussion, I think. Major questions doctrine and various other points like that. But simply, what is the nature of the exercise of authority by the legislature? And I think that the text is law account is giving us a misleading picture of that. And I think you'd say this is an unreal worry on my part. My worry, whenever I read theories here, including those that make extensive use of the distinction between lex and use, is that they will obscure or fail to attend adequately to the authoritative act on the part of the body in whom authority has been vested, which does have to be understood in a certain context, not just the linguistic context, but the whole of the law. But I'm wary of loss of a grasp on that authoritative act. Now, you might say it's an unreal worry, but I think we need to keep in mind that the significance of the individual authoritative act.
You said the whole of the law you meant use. Yeah.
Okay. Thank you. Okay. There's someone in the third row here on the side. The microphone's coming. Thank you.
So I take your point that the object of statutory interpretation should be the intended legal change that the statute is intended to make. But I don't think it necessarily follows from that anything is a better guide to what you could call the plan of action expressible in words than the text is. So my question is, if you see a textualist who takes your first point but rejects the claim that anything else is a better guide, have you done much to destabilize textualism or move people off the ball? Or can textualists still hold to that second proposition as a rule that should not be deviated from, even in exceptional cases?
Thank you. It's a good question, obviously. And certainly I think of a sophisticated textualism of the kind that John Manning has done so much work on as an effect, advancing such an argument, effectively agreeing, it's not a concession necessarily, that legislating is intentional, but saying the only way to understand the intention is by sticking as closely as possible to the textual meaning. And I agree with that up to a point, but I think the point doesn't go as far as the suggestion by Manning and others goes. Because certainly, the text that is promulgated is overwhelmingly important. It's been chosen with care. It indicates what meaning and lawmaking choice has been made. We have to make sense of it as an intelligent use of language and an intelligent exercise of legislating. I think, though, I attempted to disrupt the claim that one one would find the intended meaning by adhering closely to textual meaning, by suggesting there's more, or rather there's less stability in the idea of plain and ordinary meaning than textualists are minded to assume or to argue. That you need to consider that the context is not somehow a sort of body that generates plain meaning, but rather a series of considerations that help you infer what was intended, and that are not limited just to a kind of stylized language user who could act for any reason or no reason. So it is a major part of my concern that we have to reason about the reasoning of the legislature. And I think John Manning, again, sophisticated textualism, would agree with that up to a point, I think, although I'm not sure could, with respect, adequately explain the use of it. But I think definitely wants to circumscribe how much reasoning you could do about the reasoning of the legislature, whereas I think that is essential. Now, that doesn't float free from reasoning about the rational active language use. The two go hand in hand. You make sense of why you would say this, because what reasons would you have for action? So I think my attempt to destabilize that claim draws on, in a way, the complexity of the practice of interpretation, which is related to the nature of legislating, to which I think a sort of a minimal intention approach, although having a kind of appeal to it and being adopted by some very, very clever people, is inadequate as an explanation. Thank you. Sorry, in the front here and then in the back.
My question keys off that, which I guess is, what's really wrong with minimal intent? Because you could imagine that the presumptions about Congress being a rational actor and pursuing goals, for reasons, are all lumped into the rest of the law. And so all we need is minimal intent that, we want this text to be run through the law machine. And then all those other presumptions are also there, but they just don't come in at the front end, they come in at the back end. And the reason I ask is keying off the other question, we know that there are cases in which literally zero congressmen read the text of the law. Like they go to their staff, they say, we want you to draft up something that does the following 8 things. Staff comes back with an 8,000-page bill. They're like, looks great to us. They ship it. And clearly as a sort of real matter, their intention in voting aye was whatever's in this bill is probably good enough, and I don't know what it is, but I want it to be run through the law machine and added to our law in this way. So why isn't minimal intent enough to capture that?
I'll take your word for it that this is a feature of your practice. Unfortunately, so, yeah. I think at least some British legislators read some legislation, but it certainly could happen. And I think the distinction between the legislators plural and the legislature is vital there. And I think partly it's a distinction being recognised in the scenario. And there's very good reasons why the law doesn't allow us to look fully behind, so to speak. It takes it that the legislature, which I think is a truth, is an institution that acts, and thus that its action can have a rational coherence to it, can disclose a plan, can make changes that are not reducible to this is what a majority or even most or a sizable minority of legislators thought and intended. So the legislators themselves certainly might not understand, if they're being irresponsible, if they all are, what it is that they're doing together. I think it's consistent with the subjects of the law understanding themselves to be subject to a rational agent that is acting to change the law. I think that's different to run it through the law machine and whatever is spat out is the law in question. And it's true that the legislators in your scenario are relying on the fact that people are going to take them to be a rational legislature. When we do that, though, I think it's more than simply. I think Steve, you're running together, or the scenario runs together. Each legislator having the minimum intention with the legislature's intention is the minimum intention, and those are not the same, I think. And I think that's importantly different. And when it comes to inferring what legal change has been made, what the meaning of the statute is, I don't think there that the set of materials you refer, I think, to presumptions and various others, and you've done a lot of important work on mapping what's going on there. I don't think that forms a set that can determine what is meant, unless you having as one of the presumptions, we presume this is a rational, intentional lawmaker that is not out of its mind or so on. That, I think, is quite a different sort of presumption to all the other ones, which are cues as to what is likely to be going on in this recurring domain and there. But running through, quite apart from that sort of stabilized aspect of our practice, are particular contingent ad hoc inferences about what was decided, what was done. And those, I think, are all the business of grappling with what it is the legislature did this time, in this particular context, which may not recur. Thank you. Sorry, there was someone in the middle here, please, yeah. Oh, several someones, but you're first. Thank you.
Hi, Professor. Thanks for the talk. Assuming a judge accepts your argument that the legislative intent should control, should they be looking at what the legislature should have done or would have done in that particular case or controversy that's before them, or should they be looking at broader goals, sort of the intentionalism versus purposivism debate?
So maybe I just have an allergy to isms, so I'm not sure on quite where the purposivism, intentionalism divide would come up there. But the question is obviously a very good one about what exactly is being determined. By invoking purposivism, I wonder if you're suggesting, is it how abstract are the purposes or the ends being sought? And I think there are abstract ends. So legislatures are agents that have some abstract ends in mind, certainly, and that span legislating. But they're not pursuing abstract ends in isolation. They're pursuing a plan that will have particular ends and then a series of nested particular ends. That is quite different to the legislature will have anticipated and resolved this particular question is before the court now, which may well turn on the application of a general proposition, which could be vague or marginal and so on. I think our task is to determine the general propositions that the legislature has introduced, but those importantly are different to abstract purposes, because no responsible legislature is just tossing a purpose into the mix and then seeing what happens next. They'll act for purposes, but a nested cluster of purposes where we should know that they're not going to pursue any purpose come what may. There'll always be judgments made about competing ends and considerations and so on. So I think from time to time, this particular controversy will have been front and centre, and the legislature will have made a rule, adopted a proposition that will speak to this such that, in a way, it's settled by inferring what the legislature has decided. But routinely, I think, the legislature is making general rules that then fall to be applied. Our task is to determine those general rules. That, I think, is pretty different, importantly different to more abstract purposes, which I think there are risks of slippage in several directions, but that's certainly a familiar one. So someone, that's the end of the oh, sorry, yes. Okay, thank you.
Hi, thank you. Can you explain why the intention of the legislature is not the aggregation of the intents of all its members?
It was a short question. The short answer was tricky. I think. So I've attempted to do so at length elsewhere. If you're interested, see what I said elsewhere. But very briefly, I think aggregation doesn't work in getting us a collective action. So there just is nothing there if you're relying on aggregation. And I think aggregation isn't faithful to actually the way the legislators themselves are forming and inhabiting the legislature, animating it. It matters to the individual legislators and the many legislators that the legislature is the institution that has authority and acts. So I think it wouldn't work as a way of explaining legislative intent, as I've argued elsewhere, and it's not faithful to the way in which legislative action is taking place. Thank you very much indeed.